Who's here on Cameron Scott?
Duration for early termination.
Okay.
We probably don't have that. You have two files on Mr. Scott, Judge, that 2021
Mhm.
case has already been terminated. That was,
Okay.
that's expired already. That was terminated.
Okay. So that just leaves there.
This is the 2017 cause number. Did you need a copy of the request for early term? Because
Yes.
this might be, those might be the older copies.
Okay, yes, I think it is. It's from October.
Right. Ignore the black ones and the red ones. Right.
Okay, no problem. The other thing is you always have to report. So right now, they've handed me these cases. I'm gonna make sure that everybody has their discovery. And the defense is entitled to discovery because you want to know if the state is charging you with murder. You want to know, okay, what do you have to prove that I committed this murder? So the attorney can talk to them. Okay. All right, Troy Trevino. Why do I have this case? Troy Trevino. Okay, and where is Trevino?
He's right here.
Yes.
Forget where I'm standing.
Oh, you're right here?
Right.
All right. Yes.
Yes, Judge. So my client has he has several cases, one with several with family violence and several with criminal trial division. They are working together to try to get us a comprehensive deal and first offer is a first setting. Even a 2-week reset just to give them some time to get us a first offer. We come back and see what we can do from there.
All right, Ms. Ferguson, if I can have a 2-week reset on Trevino, please. And just set it as discovery. And state, will you have an offer by that time?
We should get you off.
Is
All
it
right.
possible to do the 9th? Only because the 8th is getting complicated. Could we do the 9th the very next day?
All right, the 9th. Do it for the 10th then.
Thank you, Judge.
The 10th, Norm, is that okay? Yes. All right, we'll bring you back on the 10th. Do you have any questions?
Thank you, Judge. May we excuse?
Yes.
He's in custody. Yeah.
Thank you.
All right. Who is here on Vanessa Rubio? Hello. All right, are you all ready to proceed?
No, Judge, I need time to get some medical records from her. It's gonna be an open plea to the court.
All right, so if you want to enter your plea now and then I can reset it for records, but we were here in May for medical issues with your client. And so
Right, that's
now,
what we need.
Yeah.
Those are the records that we need to get.
all right, if she wants to enter her plea now, and then I can reset it for whatever records you want to obtain.
Yeah, let me talk to her.
All right. All right, the court is calling 2023 CR 4281A State versus Vanessa Faye Rubio. Can I have parties announced?
Megan Galloway for the state.
Alfonso Otero on behalf of Ms. Rubio.
Are you Ms. Rubio?
Yes, I am.
All right, did you review the document entitled Motion to Revoke Community Supervision and State's Motion to Supplement Pending Motion to Revoke Probation with your attorney? Did you understand it?
Yes, I did.
Are you the same Vanessa Faye Rubio who was placed on community supervision in 2023 CR 4281A for the offense of theft of a firearm on August 7, 2023 for a term of 4 years? Is that you?
Yes.
All right, state.
Violation of condition number 4 in Bear County, Texas, the defendant Vanessa Faye Rubio did then and there fail to report to the supervision officer as directed for the months of April, May, June, July, August, September, October, November, and December 2024 in violation of condition number 4.
How do you plead to that? True or not true?
True. In violation of condition number 4, in Bear County, Texas, the defendant Vanessa Faye Rubio did then and there fail to report to the supervision officer as directed for the months of January, February, and March 2025 in violation of condition number 4.
How do you plead to that? True or not true?
True. And we'll waive and abandon the remainders, Your Honor.
Any objections?
No, Judge.
All right. Did you understand by pleading true to violations 4 and 4, the court could find it true, grant the motion, and sentence you up to 2 years in the state jail facility?
Yes.
Knowing that, do you still wish to plead true to violations 4 and 4?
Yes.
All right, the court will find violations 4 and 4 true. Is there an agreement or no?
No,
No.
Judge, it is the case we talked about that we
Yes.
need the
No,
medical. record.
I remember. I'm just trying to see if there's an agreement. All right, we can go off the record. So here's the thing. I did receive information that your client was in the hospital. I think the state is aware of that as well. So the real question is going to be when? And are we saying that she was in the hospital for these months that she did not report?
She lost her sight for a while, so we need the documents to see exactly what happened, so the court can consider how that may have impacted.
I mean, I'll consider it, but we go back to whether or not these months that you've pled true to of not reporting, whether or not this was the time you were in the hospital. I mean, that's what I want to know. Because if this is not the time you were in the hospital, then you're being in the hospital, that's just sort of mitigation, but it's not really an excuse for not reporting. For example, April through December 2024, if you're in the hospital for all of that time, then the court will understand, okay, she can't do things because she's in the hospital. But if you were not in the hospital for those days, then the question that I would want, and I'm giving you all this information so that I can get this type of information. The question I would want to know is, where were you and why were you not reporting? And it goes the same for January, February, March 2025. Where were you if you were not in the hospital? You understand?
Mhm.
So if you were not in the hospital during those time periods, you probably need to let your attorney know, because he's going to be seeking certain information to show that either probably that you were in the hospital or that you had some type of medical issue that you were overly concerned about. And that's why you didn't report. But for the court, it's easy to pick up the phone to call somebody and say, hey, I'm having medical issues. So this is the type of information I'm going to want. But if that information is not there, then don't have your attorney spinning his wheels to get information that does not exist. Do you understand?
Mhm.
Okay. All right. So does this information exist?
I believe that it's considered a factor, yes.
I'm sorry.
I believe it's considered a factor.
All right. So, and you're not an oath. So my question though is, these dates where you pled true to not reporting, were you in the hospital?
I was not in the hospital, no, but I was seeking care for it was it was a big issue at the time. It was concerning for myself, and I spent more time considering that. I did mess up and not call, and that's my fault. I pled true to that.
Okay. And so my understanding, you all don't have an agreement,
No.
and what would you be asking for?
Well, just give.
No, I mean, if you
No,
were,
what would I-
if you're just, I'm just trying to figure out where we are, so I'll know.
Yeah,
What
yeah,
would you
yes,
be asking for?
To keep her on probation, there's ISF recommendation, or whatever the court means necessary to bring the defendant in compliance, and having an opportunity to continue her treatment for her eyes.
All right, and state, what would you be asking for?
We're asking for revocation and 2 years in the state jail.
Okay, All right, so now I know where everyone is and you know where everyone is. So how long is it gonna take for you to get the information you're seeking?
I think the jail has him. I mean, I probably can try to, she's going back and sign a HIPAA for me. And once that's done, I just contact the jail and see what they have for me.
So does the jail have this information?
Yes, because I used UT Health for all of the treatment before I was incarcerated as well. So they have access to all the records.
Okay, so then maybe if you have one of the nurses there, if she signs HIPAA, then you can have the nurse Zoom in and testify if you want to do that.
That'd be great, Judge. Yes.
All right. And you say you have vacation. When would this be?
It's on the 26th to the 30th. This Thursday to Monday. I mean, I can cut it short and come back on Sunday.
No, I mean, Norma, can you recall this for July 8th? All right, is there anything else?
Nothing else, Judge.
All right, and then what I've discovered when I was a defense attorney,
Mhm.
if you just call over to the jail and ask to speak to the nurse, once you sign your release, they should be able to give him the information very quickly, but you have to do your part, okay? And counsel, if there's an issue with communicating with them, just let me know, and if you want me to see if I could help expedite things, I'll do that.
Yeah.
All right, thank you.
I'm sorry, Judge. You told me, this reset.
Yes, it's gonna be reset till July 8th. Defense counsel wants to see if he can obtain some medical records from the jail. Oh, I have it. Just give me a moment. That one I'm thinking about, counsel,
Okay.
because it's an old case.
So with this one, Judge, with regard to discovery, we believe that there's some outstanding portions at this time from Leon Valley Police Department. I know it's a smaller municipality within San Antonio, so their system isn't as automated in terms of uploading videos. In referencing the discovery, there's one PDF file with some reports, as well as one body worn cam video. There, in our estimation, maybe believe missing photos, missing videos when he was taken into custody with regard to the warrants, and a report thereafter to see if he made any statements or not. So all that stuff is outstanding. I did, Your Honor. Yes, I communicated that over to them. They said that they were going to reach out to Leon Valley as well as U-Haul to see if they can get some additional pieces of information, evidence. At this time, we believe it's lacking, that they can't necessarily prove their case. So I know that they were on board as well with having a little bit of time. If perhaps the court saw fit to reset it to July 17th, 3 weeks, in order to afford the state some time to do that, would appreciate it, Your Honor. Set it on the same date if you could.
July 7th.
Okay.
So once you sign the reset, excuse just seeing your attorney will give the document.
Thank you, Your Honor.
And what page is he on? He's on page 4. Thank you. Who's here? Noah Guerrero?
Ryan, right?
Good morning.
Good morning.
Judge, we have submitted the PTD agreement
Okay.
and I'm requesting, can we reset for July 30th? I have the 29th and the 31st. She told me to ask you because she said the 29th or 31st is 30th. Okay.
July 30th?
Yes, Your Honor.
All right, Norma, July 30th. Yes.
Okay. Thank you, Judge. Just
All right, once you find the recess on your. Okay, fine, thank you. Bill Grant? Mr. Grant, how are you doing?
Doing all right.
All right, counsel, did your client want a bench trial or a jury trial?
Jury trial, he wants to hire another lawyer on it, Your Honor.
All right, so you want to hire another attorney?
Yes, ma'am.
And how long is it gonna take you to hire an attorney?
I hired him like a couple of days ago. And
Oh, you've already hired an attorney?
uh-huh,
And who is this attorney?
I'm Michael Sawyer.
All right, so then, and has he filed a notice of retained counsel?
Yes, ma'am.
Oh, then defense, you're excused.
Thank you, Judge.
Thank you. All right, just have a seat. We'll wait for your attorney to appear.
All right, thank you.
They're not ready on this. Matthew Insuriaga. Hello. Hi, how are you doing?
How you doing?
Let me find you on the docket. All right, so docket here starts at 9 a.m., not 9:05, 9:15.
It's not.
You understand?
It's not.
So why were you late?
I was in the wrong courthouse.
All right, so you should have known this is the courthouse you need to be in because you've been here twice before.
Yes, ma'am. No, I just came from the other side, so I thought I was in the right.
Well, let
place.
me explain something to you. If I were not here, and if there were another judge here, you know what they would do? Take you into custody and give you a remand without bond. There are other judges who sat for me before, and when they call your name and you're not there to answer it, and they're calling the docket, even if they have not finished calling the docket, they would take you into custody. So this is very important, and you need to make sure you're on time. You understand?
Yes, ma'am. Apologies.
All right, Ms. Ferguson, set this for the second week in July. Your attorney is currently in a jury trial.
Okay. Yes, ma'am.
All right, July 8th. Once you sign the reset form, you excuse and make sure you're on time next time, okay?
My apologies.
You're welcome.
Okay.
All right, thank you. And are you Mr. Bill?
Yes, ma'am.
And you all are here to enter a plea?
Yes, ma'am.
All right, counsel, have you received all discovery in this case and did you review it with your client?
I have, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Bill, did you review the document entitled Application for Community Supervision or Deferred Adjudication with your attorney?
Yes, ma'am.
Did you understand it?
Yes, ma'am.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
No, Judge. Waive the repeat offender enhancement allegation.
Any objection? All right, Mr. Bill, did you review the document entitled Court Admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
All right, you're charged with unlawfully carrying a weapon with a felony conviction as a second-degree felony. Range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. Did you understand by entering this plea, you were giving up those rights? And did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 20 years in prison? Did you understand that? If you were not to do well on your probation, then I could sentence you up to 20 years. Did you understand that?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yeah, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
He has been evaluated by a psychiatrist, determined he is competent, Judge, and I agree with that.
Mr. Bill, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea? Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes.
All right, according to the plea, punishment is to be assessed at a cap of 8 years in the prison, and the state is silent on your application. Did you understand that to be the plea?
Yes, ma'am.
Defense, is that the plea?
It is, Your Honor.
State, is that the plea?
Yes, Judge.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes.
Did you understand by signing that to waiving your right to appeal, the only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court? Did you understand?
Yes.
Counsel, are there any such motions?
None, Your Honor.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State, any evidence?
Contained in Exhibit 1 and attachments.
No objection, Your Honor.
All right, state, you may be excused. Did you review the document entitled waiver and consent to stipulations with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
All right, off the record. There is no judgment in here. All right, we're back on the record. All right. Did you review the waiver and stipulations with your attorney? Did you understand it? And did you sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. Okay. 6. All right, so counsel. I know this has been pending for jury trial.
Yes, ma'am.
As you know, next week is a short week because it is 4th of July.
Okay.
And so I don't know if you would agree to recalling this for a different date. If you still want it for the 30th, but my intention was to give everyone a chance to be with their families and everything. But if you want to keep it for this date, we will keep it for the date for jury trial.
We can move it. I think we're set for July 1st, which would even be a little bit closer. Juveniles pressed me to trial on a case over there. We
Okay,
have a kid with a parent with an immigration issue, so they're trying to get us in under the bar before
all right.
something happens with ICE. So more than likely, I'm going to be in trial on Monday, and we'll probably be done by Tuesday or Wednesday, but still I'll be in trial elsewhere.
All right, so Ms. Ferguson, what do we, and I'm assuming you're not going to want to do trial immediately after that trial.
Yeah, I mean, this is my 3rd week of trial in a row, so I'm going to be a little bit tired.
If you'll speak with Ms. Ferguson, is your client on bond or in custody?
She's on bond. I have good contact with her.
All right, if you'll speak with Ms. Ferguson on a new trial date,
Good day.
and if y'all want a bench trial, I'm here.
Problem is Zach. So
Yeah.
even if it's guilt, I
Yeah.
kind of have to go to a jury.
No, I understand
Otherwise,
with the punishment.
yes, ma'am. And I researched it. You can't get,
No, you can't.
no, there's no way around it. I'm sorry. I'm gonna be out of the country from August first, 15th,
Oh, where are you going?
Alaska, going salmon fishing.
Okay, why do you call that out of the country?
Because it's not in the proper continental US. Also, I'm going to Canada and we're going into Canada too, keep
Okay.
territory.
All right.
So. That should work. Yeah. Good.
Okay.
Person, I love Alaska. I love Canada. Sorry, I'll find that. We're gonna be, I'm not sure who we're.
No, let's keep it for the 22nd.
And they include the open drink, drinks, but include the open drink package.
Okay, on Gilmore, I don't have a docket sheet. Yes. It's 2024. Oh, just one second. It's towards the very back. All right, State on Gilmore, you're opposed to early term? All right, have y'all spoke to the complainant?
Yeah,
And what does the complainant want?
she's not want early term.
Okay. All right, well, his attorney, Mr. Gilmore, if you've come forward, please. All right, Mr. Gilmore, your attorney is actually in a jury trial, so I'm gonna have to reset it so that he can be here. And present whatever arguments he wants to the court. I mean, you've heard the state, the complainant does not want you to have early termination. That doesn't mean that I'm not going to grant early termination. These are just all things that I consider when making a decision. So we're going to what we'll do is, because it's your attorney's motion, we'll just let the court know when they want it set and we'll hear it, okay? And then your attorney will get in contact with you with the new date. All right, thank you. Thank you so much. No, you don't. What will end up happening is your attorney will call us or come by and say, can you place this on the docket? And we would have released you earlier, but we just received notice that that your attorney was in jury trial.
Yes, ma'am.
All right, so just get in touch with him and he'll put it on the docket and we'll set it.
Thank you.
Excuse me, sir. I'm being told that it may have been filed by probation, a request for early term.
Yes.
All right, so what we'll do is we'll still reset it. Just call your attorney still. All right, thank you. All right, so here's the thing. They want you to be continued. I can continue you. I don't know if you're going to be successful on this or not.
Yes, ma'am.
Or I can send you to the state jail facility for 180 days. And the reason why I'm saying 180 days is because of the fact that you've obtained your GED, and I'm glad you're on the right track, and that you have, worked towards rehabilitating yourself. So this is what you need to think long and hard about. The 180 days, you do your 180 days, you'll be done. You get credit for whatever time that you've previously done, or you're going to continue to be on probation. You're already on regular probation, which means this is already a felony conviction. So if you want to discuss that with your attorney, you can. And if you want to talk to them to see how much time she has.
She has, I believe, Judge, according to probation, she has 227 days credit.
Well, what I can tell you is, because this is a state jail felony case, they may release you from the jail, but legally what they're going to do is they're going to take you and process you at the state jail facility. And if you have credit that's beyond 180 days, they'll release you from the state jail facility.
You want to do that?
All right, so here's the thing. We're out the record. Here's the thing. It's your decision. This is what I'm telling you, and I want you to hear me and internalize what I'm saying. For a lot of people, going to the state jail facility, going to the Bexar County Jail, going to prison, that's a frightening experience, right? We don't know what's going to happen. But what I can tell you is I'm willing to sentence you to 180 days at the state jail facility. State jail facility, that's day for day time. What everybody is telling me is that you've already satisfied that time. But because it's a state jail facility, normally and legally, they don't release you. They're not supposed to release you from the Bexar County Jail. Now, I've heard situations where people have been released from the Bexar County Jail, even though they're supposed to be processed through the state jail facility. What I'm telling you is legally, they're supposed to take you to the state jail facility, process you. They'll see that you have enough days for the judgment to be satisfied, and they'll release you from the state jail facility. Otherwise, you're going to be on probation in this court for another 2 years.
I'll do the 186.
All right. Are you waiving your right to appeal?
Yes.
Well, not I guess. So if you want me to give you the 180 days, then that's something that you're asking me to do. That's something that your counsel is asking me to do. And I think the state is going to be asking me to do that. And do you want me to follow that?
Yes, ma'am.
And are you waiving your right to appeal?
Yes, ma'am.
All right. The court is finding violations of 4 and 4 true. The court will sentence you to 180 days in the state jail facility. Give you credit for any time served. The court will show that the judgment is satisfied. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. You understand?
Yes, ma'am.
All right, we can go off the record. Here's the thing. You don't have probation hanging over your head, but you still need to remain vigilant, because otherwise you're going to end up right back here. Don't be celebrating, woo, I'm off of probation. Ooh, I'm out of jail, because that's when you start backsliding. So write down what your program is for your life and follow that program. And anybody who tries to stray you from that path, you need to kick them to the curb. You understand?
Yes, ma'am.
And I'll be here. If I'm here when you get out and you can't find what you're looking for, you can come back here and we can look online and find a place for you. Okay?
Yes, ma'am.
All right. Good luck to you.
Thank you, Judge.
You're welcome.
Good to see you.
You
Thank
too.
you. Be excused.
Yes. Who's here on Constance Sinwell? Yes. Good morning. Where's your client?
She's in the back, Judge, but we're just here to, for a status on the doctor.
Mm-hmm.
What I was told by court administration and everybody else that I didn't know is that I guess she's just supposed to be referred to mag court and they will do the evaluation.
That's not how that's supposed to be, because you're requesting a sanity evaluation, correct?
Well, I just did a notice of insanity, Judge, and
All right. So you're just doing sanity?
just insanity, not competence.
All right. So yeah, you have to file a motion for that, and they should take care of it in the magistrate's court.
Correct. Okay, so okay, Judge, well, maybe I've
Yeah.
done an insanity defense in
No, no,
20
no,
years. Okay, I thought she would just be referred on my notice. So I can file that motion today, Judge.
Yes, awesome. And then check in with them.
Okay, we'll do.
All right, Norma, recall this for the 28th. January, July.
Judge, I'll come check in when I get that done too.
All right, thank you. Monica Guerrero, who do you have?
Judge, I have Mr. Smarter that's ready and I'm waiting for paperwork on this letter.
Okay, I don't have any document on Smarto.
He was sworn in already.
Ah. Can I have a file stamp, please? And after this case, the court is going on recess, and I'll have everyone back at 2.
Thank you.
Court is calling 2025 CR 005464 State versus Joseph Greenwood Smarto. Could I have parties announced?
Megan Galloway for the state.
Monica Guerrero for Mr. Smarter, Your Honor.
And counsel, is this an application?
It is not.
Okay. Are you Mr. Smarto?
Sure.
All right, counsel, have you received all discovery and did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Smarto, did you review the true bill of indictment with your attorney? Did you understand it? Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
No, Your Honor, we're waiving the habitual enhancement.
And we have no objection to that and believe they're only proceeding on count one.
Yeah, that's correct, yeah.
All right, Mr. Smarto, did you review the document entitled Court Admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Did you understand you're charged with a manufacturing delivery of a controlled substance, penalty group 1, 4,200 grams as a first-degree felony? Range of punishment is anywhere from 5 to 99 years or life in prison and up to a $10,000 fine.
Yes, Your Honor.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand? You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state would call in the right to remain silent. By entering this plea, you are giving up those rights. Did you intend to give up those rights in this case?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
He has, Judge.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Smarto, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea? Anyone promised you anything other than the plea? Are you satisfied with the way you've been represented?
Yes, sir.
Are you a U.S. citizen? Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, sir.
According to the plea, punishment is to be assessed at 8 years in the prison. There's a $2,000 fine and no applications. Did you understand that to be the plea?
Yes, sir.
Defense, is that the plea?
It is, Your Honor.
State, is that the plea?
It is, Your
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal?
Yes.
The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, are there any such motions?
No, Your Honor.
Then to count one in the indictment, how do you plead? Guilty, not guilty, or no contest? State any evidence to support the defendant's plea?
State offers states one in attachments.
No objection.
All right, state, you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
He's been very honest from the get-go, including in the police report. We'd just like the court to accept his plea agreement.
All right. The court will find you guilty. The court will sentence you to 8 years in the prison. Give you credit for any time served. There's a $2,000 fine, time and money to run concurrently. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? Because this is plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right, we can go off the record. Here's the thing. Fast money, not good money. I bet you end up with fast money and you don't even know where it went. You can't point to anything and say, that's what I bought it with. This is what my grandmother would always tell me. And I do my best to live by that. And she said, you cannot build your happiness off somebody's misery. And there are people who are suffering from drug addictions, and you can't build your happiness off of that. You understand? When you're released from prison, if you have an issue with drugs yourself, if you have an issue with housing or whatever it may be, if I'm still here, you can come by. I will pick up the phone and call someplace to help you, okay? All right, good luck to you.
Thank you.
Thank you.
It'll be excused.
Yes, everyone, we're taking our recess. We'll be back at 2.
Judge, I'm sorry to bother you.
All right, we're off the record. So here's my question. I always say, I don't know all of the law. But is it illegal to smoke in a city park?
I believe it is, Your Honor.
Well, I mean, let's not go on beliefs.
I don't know.
Is there a law? Does any attorney know? We're off the record. Does any attorney know whether or not it's illegal and arrestable offense to smoke in a city park? I don't know that off the top of my head. All right, so for both parties, the first hurdle I need to get over to see whether or not there's an issue here is for whether or not it's illegal to smoke in a city park, because they're saying that they arrested him for smoking in a city park, and then that led to everything else. So I don't know the answer to that. So if you all can come back at 1:30.
Judge, my wife has been very sick. Been up all night with her. She had spinal surgery about 30
Are
months.
you able to appear by Zoom?
Sorry,
Are you able to appear by Zoom?
I didn't hear you.
Are you able to appear by Zoom?
Yes,
All right, so you can come back by Zoom.
yes, ma'am.
All right, if somebody could make sure that Mr. Bell is back by 1:30, and I'll research to see that answer, because I don't know that one off the top of my head.
Thank you, Judge.
All right, thank you. No, it's probably best that you not say anything. All right. All right, who's here on Vincent Savage? Norma Bill is gonna come back at 1:30. All right, so in this case where you're on
Yes,
discovery,
ma'am. I conferred briefly with Mr. Edelman.
everyone, please whisper.
I was told that it's been re-indicted. They don't have the file down here. They're looking for it. So I haven't had a chance to review it today. I also don't, as of now, I don't know. They're still looking into whether or not they've spoken to a victim, so.
All right, Ms. Ferguson, I need a 3-week reset date, please, on Savage. All right, July 10th.
Yes, ma'am. Thank you, Judge.
All right, we'll come back on July 10th, sir.
Thank you, Judge.
I just sent you an email, Judge. Thank you. Who is here on Ricardo Vargas?
Hello, Judge.
Hello. So today is plea deadline date.
It is plea deadline date. However, Judge, there's one other discovery matter. I haven't looked at the body cam that I
Okay.
needed to, and I know I needed to do that last setting, but I haven't got it done.
All right, Ms. Ferguson, can we recall this in 3 weeks, please? All right, that will be your final plea deadline date.
Thank you, Judge.
All right, anything else, counsel?
Nothing else, Judge.
All right,
That's all
once
we-
you sign the reset form, you are excused.
All right, thank you.
You're welcome. And what page is he on, Norma? Ricardo Vargas. All right, thank you.
Judge,
Oh, I'll deal with that in a moment. Let me finish this because they're coming back in the afternoon anyway. But I appreciate you. Dorian Camarillo. Hello. All right. Hello. So on this one, we're still doing discovery, correct?
That's correct.
You got extra change on.
Yeah, sometimes. It reminds me of, every year we would watch, the Ten Commandments. Oh, no, not Roots, but Ten Commandments every Easter. And you know what he said? If he a myth, bring him to me in a bottle. If he be a man, bring him to me in chains.
Like that.
Oh, that was a program. We still watch it. That's an Easter classic, right?
So it be written, so it
Be done. I'm gonna violate my final law on my deathbed and say his name. Moses. All right, so we're coming back on this case on July 24th.
That's correct, Judge.
Okay.
Now, another thing that we have is there's a motion for a bond reduction.
All righty.
So
Are you able to come back at 1:30 and I'll hear that?
you make it 1:30.
All right, Norma Camarillo is 1:30 for a motion to reduce bond.
Somebody.
Okay. We'll pick it up. Greenwood.
Good morning, Judge.
Good morning. So how are you doing?
Hey, Judge, how are you?
All right, on this case, she hasn't entered a plea, has she?
Not yet, Judge.
All right, the court is calling 2017 CR 6646B, State versus Imari Greenwood. Could I have parties announced?
Megan Galloway for the state.
Alma Benavides from Miss Greenwood.
And are you Miss Greenwood?
Yes, ma'am.
All right, Ms. Greenwood, did you review the motion to revoke community supervision and state's motion to supplement pending motion to revoke probation with your attorney?
Yes, ma'am.
Did you understand it?
Yes, ma'am.
Are you the same Amari Raisha Greenwood, who was placed on community supervision in 2017 CR 6646B for the offense of theft of property, $2,500 to $30,000 on January 24th, 2023 for a term of 2 years? Is that you?
Yes, ma'am.
All right, state.
Violation of condition number 4 in Bear County, Texas, the defendant Amari Raisha Greenwood did then and there fail to report to the supervision officer as directed for the months of August, October, and November 2023 in violation of condition number 4.
How do you plead to that? True or not true?
True.
State.
Violation of condition number 4 in Bear County, Texas, the defendant Amari Raisha Greenwood did then and there fail to report to the supervision officer as directed for the months of January, February, March, April, and May of 2024 in violation of condition number 4.
How do you plead to that? True or not true?
True. We waive and abandon the remainders, Your Honor.
Any objection?
No objection.
Did you understand by pleading true to 4 and 4, the court could find it true, grant the motion, sentence you up to 1 year in the state jail facility?
Yes, ma'am.
Knowing that, do you still wish to plead true to violations 4 and 4?
Yes, ma'am.
Court will find violations 4 and 4 true. Is there a proposed agreement?
Judge, there is, after conferring with probation, the recommendation is to deny the state's motion, extend the defendant for 1 year, alter and amend her conditions for SADIF, followed by aftercare, an updated TAP evaluation to be performed in custody, monthly UAs upon release, and sober support meetings.
All right, what has she done on probation? Has she done anything?
Judge, I do want to point out the top evaluation was already complete. That was done last month, and that is the new recommendation is for the SADF.
I don't think you're a good candidate for probation. Let me just tell you why. This is not your first motion to revoke. And it's the same thing. And in 2023, you were here for a motion to revoke. And a TAP evaluation was done. They did GPS. So, I mean, what have you been doing since then? You want to raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
Imari Raisha Greenwood.
All right, so what have you done since you've been on probation?
I got my GED.
Oh, that's great.
Yes,
Okay.
ma'am. I am in school currently. Going to cosmetology school, and I enrolled in Southern University, working in my associate's degree. I understand that I messed up, and I'm truly sorry. I'm not the same person I was last time you saw me. I totally made a turnaround in my life. I'm tired of this. I'm almost 30. I just want to move forward in my life. I understand I messed up. Yes, I just truly want to move forward. And in between time, I was going through a lot. It's not an excuse because that wouldn't make it, that didn't make a difference, but I truly am a different person and I have stuff going on out there. And I do not want to be locked up. I'm tired of this. I just want to.
I like your purse today.
Thank you. The circle is going. Last night, my phone did the same thing and I was like,
Mm.
I call it the wheel of death,
yeah.
because it usually ends up killing the computer.
Mm.
Okay, yes.
Yes, you were, I was called in to see you about coming up.
So anyway, you're scheduled for jury trial on the 30th.
Yes.
And if you all want to go on the 30th, of course,
And you'll.
we'll make it happen.
But you wouldn't mind if I work continuance?
I mean, if you want to,
I'll
you
work
can.
continuance.
All right. So what we'll do is your client in custody?
No,
All right. And is he going to have any objections?
no.
All right. And the only reason why is because next week is a short week.
Mhm.
And then I know that other people have travel plans with their family and everything.
Oh, July 4th, that's right.
Yeah.
Oh, very nice.
So that is why. But if anyone wanted to have their trial,
I've
we
got
would do
another
it.
one specially set for the 30th as well, so. that'll
Okay.
Free me up to just work on that one.
All right. So if you all will speak with Miss Ferguson on a date, then we will make it happen.
Thank you, Judge.
You're
Have a
welcome.
good day.
You too.
Thanks. November. What are you thinking? August.
Oh, Norma, who is on the Capitol in August? Is that going? Yeah, no, no, no. I mean, I know, but I don't know if that's going to work out or not. Probably not. All right. Then don't put them during that week, and that trial should just take a week.
Number 8.
And actually, Norma, they're saying that we may end up having an impact court coming soon with juries.
They'll build that bridge till we get there.
Oh, I'm not going to build it.
Got a couple federal settings on probably okay. If it's Tuesday.
Yeah.
Okay. Right, that's
You're here
fine.
for Mr. Augustine?
Yes, that's fine. All right, thanks, counsel. And defense? Mr. McCrom.
Yes, Judge.
Hi. So you're not charged for a continuance for that, just so you know.
Okay, thank you.
All right, thank you.
Good morning, how are you? Hold on, back to that.
All right, let's talk about that. This hearing was a full display of Judge Boyd's steady courtroom management. She kept the docket moving at a brisk pace while still making time for clarity and fairness, especially when working through a range of cases that touched everything from probation violations to plea agreements. Her style was firm but approachable. She took care to explain legal procedures in plain English, even sprinkling in some humor. Give a mouse a cookie, he's going to want a glass of milk. And personal anecdotes to keep the atmosphere grounded. Boyd's ability to balance efficiency with empathy stood out, especially when she paused to advise defendants about their futures and encourage them to make better choices rather than just process them through the system. One notable moment came with Vanessa Rubio's case, where her health issues had complicated her ability to comply with probation. Instead of rushing, Judge Boyd and counsel dug into timelines and medical records to ensure decisions were based on context, not assumptions. That thoroughness carried through to other cases, like Imari Greenwood's, where the judge pressed the defendant to take responsibility, but also acknowledged progress, including earning a GED and pursuing higher education. These conversations weren't about lecturing. They were about setting expectations while leaving a door open for growth. Defense attorneys and prosecutors were generally well prepared, though some requests for resets highlighted how coordination with smaller agencies can slow things down. The tone remained professional, even when logistics got messy, and Boyd often offered guidance to help attorneys streamline communication with the jail or probation office, a practical touch that reflects her experience. Witnesses and participants contributed to the hearing's measured pace with no drama or hostility. Even when dealing with heavy subject matter, Boyd maintained a calm courtroom, occasionally lightening the mood with humor, but never undermining the seriousness of the proceedings. The plea hearings themselves showed a balance between procedure and personalization. Defendants were walked through their rights and consequences in detail, with Boyd frequently reminding them about the real-world implications of their choices. Her comments about fast money not being good money and refusing to let people backslide after release reinforced her reputation as a judge who blends compassion with accountability. Overall, the courtroom atmosphere was orderly but personable, like a well-run machine that hasn't forgotten it's dealing with people. Judge Boyd's mix of humor, patience, and high expectations set the tone, while attorneys' professionalism and defendants' candid testimonies added depth. This wasn't a flashy or contentious hearing. It was a steady day in court, with a judge who knows her docket and a team that respects the process. If you found this hearing insightful, consider subscribing, hitting the bell, and letting me know your thoughts in the comments below. I read every one.